Was the plaintiff a leveraged finance sex slave, or is the whole story made up? Is this a case about sexual assault and discrimination, or is it a lie, and is it just defamation? May it please the audience, I'm Rich Schoenstein. Welcome to So Sue Me, the podcast about civil litigation. And today we have a doozy of a civil litigation to talk about, filed in the New York State Supreme Court, County of New York. All right, here we have it. Index number 155620, 2026, the case of John Doe v. JPMorgan Chase Company and Lorna Hagina. We now know the name of the plaintiff. That's been revealed in a lot of reporting. I'm not going to say it because it's still John Doe in the official filing, but you'll hear more about who he is. Here are a picture of the plaintiff and the defendant. Attribution to News Nation. I was on News Nation last night talking about this case. I got a call to go on Jesse Weber's show, and his booking producer said, Jesse thought of you when he heard about this case. And I said, great, let me take a look. And then I looked at the case and the allegations, and I thought to myself, oh, he thought of me? Well, that's nice. Anyway, as I said, this is a crazy case. So here's the summons and complaint right off of the New York docket system. You can see this was filed on May 4th, 2026. And then we have from the individual defendant answer defenses and counterclaims filed just 15 days later on May 19th, 2026. And the first thing that stood out to me is how quickly those counterclaims were brought. Usually you have 20 or 30 days at a minimum. Often you negotiate for extensions. Sometimes there's motion practice before an answer, but this answer was brought 2 weeks after the complaint, very promptly. So this is a defendant who wanted to say something publicly and say it quickly. Now, let me tell you a little about the case. The case arises in the field of leveraged finance. If you don't know what that is, it's corporate speak for raising debt, raising money by debt for companies, for individuals to do things, really often to start up a company or some new type of endeavor. And instead of getting a bank loan, they get leveraged finance, which is debt that is then sold to hedge funds, syndicated to pension funds, other kinds of sophisticated investors who sort of group source the financing that is then used for whatever purpose it's used. But the giant investment banks, and JPMorgan Chase is in this case as an investment bank, not as a retail bank, not as your bank down the street that has your retail accounts, but as an investment bank doing these giant deals worth millions and millions, hundreds of millions of dollars, and big time players. And, you know, in that kind of work, it's very round the clock, very stressful. And sometimes you see sort of craziness arise in that context. And that's what is alleged here. The plaintiff in this case says that he was on the JPMorgan Chase leverage finance team, and that a superior member of that team, a female, basically made him have sex with her multiple times, including drugging him, both with the date rape drug and with performance enhancement drugs at the same time. There's a lot of very salacious allegations in this complaint. I'm not going to get into it, but not only that she essentially assaulted him sexually, but that in the process she demeaned him. She spoke to him about his ethnicity and race in a derogatory and harassing manner, that she was bigoted in that regard, and basically assaulted him both physically and emotionally. And then the complaint alleges that he raised these complaints with JPMorgan Chase and they disregarded them and didn't pursue them adequately, and that he was ultimately forced to leave the company, actually removed from the company. Now, the defendant has responded vehemently that none of that is true. She says, first of all, they never had sex. Second of all, she's never even been to the apartment where he claims they had sex. Third of all, that she never was, in fact, his superior, even though they were on the same team together. And so she denies all of the allegations and has brought counterclaims, including a counterclaim for defamation that we'll talk about in a minute. So here we go. You can see plaintiff's claims. He has claims under the New York City human rights law and the New York State human rights law, two separate laws for gender discrimination, race discrimination, and retaliation, saying the bank retaliated against him when he raises concerns. He has a claim for sexual assault against the individual defendant. He has claims under the New York labor law wage claim provision, saying he wasn't adequately paid. He has claims for tortious interference, saying that the defendants interfered with his efforts to get a new job. And he has a claim for defamation, saying that essentially he was called a liar and called other names. Defendant has brought counterclaims, as I said, essentially a counterclaim for defamation, and then other claims that go with that. A claim for intentional infliction of emotional distress, something we call prima facie tort, which is outrageous, tortious conduct that doesn't squarely fall in another cause of action. Tortious interference, she says that this plaintiff has tortiously interfered with her relationship with her employer. And a placeholder for malicious prosecution. There's a claim at the end of these counterclaims that say, after I prevail, I'm going to sue all these people for malicious prosecution as well and seek damages for that. So this is what I would call an absolute dirt fight. In a lot of cases, there are facts that appear undisputed. And really, the case is about the interpretation of those facts. What do they mean? How does the law apply? This case is not that. This case is classic he said, she said. Absolutely, totally different views of the facts. He says they had a sexual relationship that was forced upon him. He was discriminated against. He was retaliated against. He was abused. And she says none of that ever happened. And to be clear, I don't know who's telling the truth. I have no information, and I've not set about to figure out who's telling the truth. It's way too early in the case for me to do that. I think it would be irresponsible to do that. And I know maybe it would be easier to get clicks if I took one side or the other and made someone seem like the bad person and someone seem like the good person. But I can't in good conscience do that because I don't know who's telling the truth from reading these pleadings. It does appear that JPMorgan Chase conducted an internal investigation. I would assume that was pretty thorough. I would assume there were lawyers involved. That might be instructive, but still, it's not enough for me to say definitely the plaintiff is lying. It's just not enough. It's not enough for me to say that, and I can't in good conscience say the otherwise. This is a he said, she said battle. Again, this is a dirt fight. This case is the kind of case for which we have civil litigation. This case is all about credibility, about the witnesses. This case could only ever be resolved in front of a jury where these two parties testify with their versions of the facts and bring whatever other facts they have to bear into it, and a jury makes the decision. For example, the defendant in this case says this is not the first time plaintiff has done this, that plaintiff made similar allegations in a prior job, that plaintiff has in the past lied about his father dying in connection with some work stuff. So from the defendant's point of view, the plaintiff has made these kind of claims untruthfully in the past and has no credibility. The plaintiff says that he has corroborating evidence. There are suggestions in the complaint that he may have texts, he may have emails that back his story. And you simply cannot determine who's right and who's wrong without seeing the evidence and without hearing from these crucial witnesses. Now, one other thing I want to talk about, and we talked about on Jesse's show last night, are the defamation claims, because usually you cannot bring a defamation lawsuit based on something someone says in a complaint in court. Let me show you what I mean. So In the field of defamation claims, we talk about something called privilege. There are certain comments that receive absolute privilege and cannot be attacked in a defamation lawsuit. Those include things you say in judicial proceedings. We don't want people to be chilled from advocating their position in court. They should be allowed to say whatever they want in a pleading or up in court or testifying, and you cannot sue someone for defamation for that, or in legislative proceedings, or in spousal communications. And I think there are other examples. Then there are things that get qualified privilege. That means you can sue for defamation, but you would have to prove actual malice, that the defendant knew what they were saying was false or should have known. That applies to things like news reporting. We see this all the time in cases against news reporters or news organizations. They have qualified privilege. Employment references, reports to law enforcement. So the counterclaim here says that the plaintiff began his defamation of the defendant long before he filed a case in court. The claim is that the plaintiff defamed the defendant by reporting her to Human Resources at Chase, by making comments about her to fellow employees and to third parties. The report to JPMorgan Chase, the internal report, would probably be qualified privilege. If you make a complaint to HR, that gets, or by the way, to law enforcement, that gets qualified privilege, where you would have to show actual malice in order to sustain a defamation claim. Lots of things have no privilege. Things you say to people on the street has no privilege. Things you say to third parties have no privilege. So if there are allegations here that the plaintiff made these accusations of the defendant to people out in the world, separate and apart from the lawsuit, then that would have no privilege. And there have been cases where something is filed in court, but the reiterating of those allegations outside of court can constitute defamation in certain cases. So, putting all of that together, you can't counterclaim against a plaintiff who sues you and say that the lawsuit is defamation. But if that plaintiff has been saying this stuff about you out in the world, you may have defamation claims. And that's what's been asserted in this lawsuit. So there you have it. You have a monster civil litigation with highly charged, provocative, salacious allegations, really on both sides. I mean, you have a plaintiff claiming that he was made a sex slave. You have a defendant claiming that the plaintiff is just completely lying and defaming her and intentionally causing harm and, seeking to get financial gain out of it. Where does the case go from here? Well, here's the docket. You'll see that the case was commenced on April 27th, although the summons and complaint was received on May 4th. There's a little bit of practice about what in this case is going to be filed under seal and what isn't going to be filed under seal. As we say, the plaintiff put in his name as John Doe, attempting not to identify himself in the complaint, although now he's been identified. And there's some other proceedings here. There's been a judge assigned. This is signed to Judge Dakota Ramsour, who I have not been before, even though she is in the New York County Supreme Court where I practice, but there are a lot of judges down there. I don't have experience with this one. Ordinarily, in a case like this, you might see motions to dismiss on one side or another. We don't have any response in the case from JPMorgan Chase yet, so we don't know if they're going to move to dismiss any of the claims or if they're just going to put in an answer. We don't know if the plaintiff is going to move to dismiss any of the counterclaims that were just filed the other day. There could be some initial motion practice. For motion practice, you go on to discovery, an exchange of the documents that are relevant. Give us all your evidence. Give us all the documents about this plaintiff, about this defendant. And then you're going to have depositions, deposition of the plaintiff, deposition of the individual defendant, deposition of the other people of Chase. There are several others that are mentioned in the complaint as having exchanged text messages about the plaintiff or about the events at issue. So there are depositions to be had. Typically, after all that discovery, the exchange of evidence, positions, you would get motions for summary judgment where one side or sometimes both says to the judge, we don't need a trial. This case is clear enough from the evidence that's been provided to decide it. And only after you get past all of that would you go to trial. In a case like this, based on the timing, you wouldn't probably see a trial anytime before 2028. And that's challenging for the parties here because both parties claim, in essence, that their careers have been destroyed. The plaintiff claims his career has been destroyed by the abuse he suffered and the retaliation, and the defendant claims that her career has been destroyed by the accusations and all the negative attention that she's received as a result of those accusations. They may want that matter to be addressed in a courtroom and decided promptly, but the courts don't move that promptly. So it's going to be a challenging year or more in this litigation if these parties go forward. Of course, they always have an opportunity to resolve the dispute, to try to settle the dispute. That's especially difficult in a case like this where each side wants some form of public acknowledgement that they're telling the truth. It's about money, but it's not just about money. It's about name, it's about reputation, it's about the future. So you never know what the settlement prospects are looking at a case like this, but you would assume there would be discussions about it somewhere along the way. As I say, this is the kind of matter for which civil litigation exists. This is a matter where each side has a starkly different story that they're telling. And again, in a lot of cases, both sides are trying to spin the facts. In this case, one side is lying, outright, flat out lying, right? They're so diametrically opposite in what they allege, there can't be any other conclusion. Will we ever know which side that is? Remains to be seen. Remains to see what will happen in this litigation. I will follow it. It's the kind of thing that I find interesting. It's the kind of case that we do hear from time to time as well, although not involved in this one. Otherwise, I wouldn't be talking about it. All right. That's where we are in the leveraged finance, sex slave, harassment, discrimination, assault, and defamation litigation. Words I didn't necessarily see going together, but they do. Thanks a lot for watching. Don't forget to like and subscribe and all that kind of stuff. We'll see you soon. For now, we are adjourned.